Good evening and welcome to the Board of Adjustment meeting for November 18th, 2021. I'm calling the public hearing to order. Will you call the roll, please?
Yes, Ms. Hudson.
Here.
Mr. Saunders. Can you hear me, Mr. Saunders? I'll come back to Mr. Saunders. Mr. Jenkins.
Here.
Mr. Kusick.
Here.
Mr. Crossan. Mr. Nichols. Here. And Ms. Stenny.
Here. So we're just looking for...
Mr. Saunders, he was on the line. I think we'll get him back.
Okay, so when he comes on, we will remember. I mean, we do have a quorum with or
Yes,
without, but preferably I'd like to acknowledge his presence. While we're waiting for that, will you introduce the staff?
Thank you. Good evening, everyone. My name is Scott Blair. I'm one of the planners here with Kent County Planning Services. Also with me is fellow planner Jamie Fensky to my left, and Mark Kennedy will be our IT support tonight. And also at the end of the dais, we have Mr. Fred Townsend, who will be the board's legal counsel this evening.
Okay, so at this time, I'm going to ask everyone to rise and pledge allegiance to our flag. Okay, let's just check to see if Mr. Saunders is here yet.
Mr. Saunders, are you with us? Okay, apparently he is listening online. Hopefully he can
Okay,
chime
I just
in
want to
later.
be sure that he is able to listen and input. Okay. So, any additions or alterations to our agenda?
There are none.
Okay, so when you're ready, please introduce the public hearing.
Thank you. Good evening again, ladies and gentlemen. My name is Scott Blair again, and I'll preside as the hearing officer for tonight's public hearing. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on these applications before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there shall be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. The chairperson of the board has the discretion to allow additional time if deemed necessary. To make a statement when your application is called, please use the podium at the front of the room. If you are participating online and wish to give testimony, we will unmute your line so you can speak. For the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. And if you could, please speak slowly. Some people kind of want to say it quickly and we can't always get their name and address. Copies of any written statements or exhibits used during the hearing should be presented for identification so they may be included in the permanent record. The procedure on each variance application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by staff. The board will then receive testimony from all those in favor of the application, followed by testimony of those who may be opposed. Once those persons in favor and those in opposition have had the opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call Kent County Planning Department tomorrow between 8 a.m. and 5 p.m. at 744-2471 or check the Kent County Planning Department website to learn of the board's ruling. All applicants will receive written notification of the board's decision. However, this notice may not be mailed until after the next scheduled meeting. But if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearing was published on November 1st in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications. Thank you.
Thank you. At this time,
Mr. Saunders, is that you?
Yes,
well, welcome.
I'm here. All right.
Okay, at this time, we're going to have a statement by counsel, the purpose of which is to help those who are going to testify this evening to have an understanding of what is acceptable as testimony before this particular body. Mr. Townsend.
Thank you, Ms. Denny. The standards for the granting of area variances are set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty. The standard applied to area variances considers whether a literal interpretation of zoning regulations result in exceptional practical difficulties of ownership. And in order to determine whether the exceptional practical difficulty test is met, the board must weigh the following four factors. 1, the nature of the zone where the property lies. 2, the character and uses of the immediate vicinity. 3, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And 4, whether failure to remove the restrictions would create unnecessary hardship or exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is satisfied only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. Note that the inability to improve one's business or stay competitive as a result of area limitations may qualify as a legitimate exceptional practical difficulty. And it's also in this fourth factor where the board considers whether the applicant is seeking more than is minimally necessary to relieve the asserted difficulty. So in general, the board is not to consider factors other than the four I've listed. So those of you who are speaking tonight in support of or in opposition to applications are urged to present only information bearing directly on those four standards, which again are the zoning district, the character of the immediate vicinity, the effect on neighboring properties, and whether the applicant faces exceptional practical difficulties of ownership. In particular, presenters are instructed to exclude from their presentations any discussion of personal disputes or acrimony between the applicant and neighboring property owners, as the board is both unable and unauthorized to resolve those disputes. That concludes my statement.
Thank you, Mr. Townsend. Okay, so it looks like we're ready when you're ready.
Thank you. So the first application tonight is A21-40, Samuel S. Miller. Is there someone here tonight to represent the application? Sir, we'll call you up after we've presented it. Thank you. We'll just have our attorney swear you in. So again, this is A21-40, Samuel S. Miller is seeking a variance from the minimum 200 feet of road frontage to enable a minor subdivision. The property is located on the west side of Dinah's Corner Road, south of Pearson's Corner Road, west of Dover. It's in Levy Court District the 2nd, and it's zoned AR. So this is the exhibit showing the site plan. It's actually a survey showing what's being requested tonight. What's required is 200 feet of road frontage. The applicant does not have 200 feet in this case and is requesting 197.97 feet. This is the photographs taken of the site. You can see the sign posted in front of the house that's on the property to be subdivided off. This is looking down the road in one direction. Oh, okay, this is the one that's being subdivided. And this is kind of a view of the road. Did you give the general character of the area? Again, this is photos of the site, giving character, and this is an aerial photograph. The lot is up at the top. You can see a house under the M for Miller. Thank you, Jamie. That gives you an idea of what's being subdivided off to create the lot. And this is just a higher up aerial photograph of the property. Okay, if you'd like to come up and give testimony, please. Again, state your name and address so we can understand slowly, please.
My name's Jay Miller. I'm representing my father and my grandfather. My address is 6470 Millington Road, Clayton, Delaware.
Mr. Miller, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
And please continue.
So as the pictures show, when this piece of property was sectioned off from my dad, we had went along the road portion of it, and originally it marked out to be 219 feet. When we had the survey done, it marked up to be 197.97 feet. So we just didn't realize that you went in a straight line instead of going on the property of the road. And I think at that point there's no neighboring places that the 2 foot width would change anything on their properties. And my dad's looking to improve the property by putting a pole shed for his old car so he can store it out of the rain. Hoping that's as simple as it gets right there.
Mr. Miller, so ingress, egress to the property on the far left is, there's a driveway and I'm just not seeing it? Or?
Yes, there's a driveway.
There's a driveway,
Yep.
okay.
Yep. If
Okay.
you go back a couple slides, one more, maybe I'll give them. You're right there. So there's the driveway there, and it's just straight up to my
I
dad's
see
house.
it. I see
Yep.
it now. Okay. Anybody else have any questions for Mr. Miller? Mr. Townsend?
Mr. Miller, could you tell us a little bit more about why the subdivision is being made? What's the goal of the subdivision?
So my father wants to get the piece of property deeded into his name. My grandfather's getting older, as all of us do, and he just wants to make sure that that section of the property is deeded to him before something happens to my grandpa.
Anybody else? Questions? So essentially, family members live on both of these properties, live and own both of these properties?
Yeah, yep.
Okay.
Yep. Yeah, my aunt still owns the property would be the left-hand side of my dad's, and then my grandfather still owns the land.
Okay, and is there, I see this, looks like a track, is that?
Horse racing, yeah.
Horse racing?
Yeah, he's done it his whole life.
So he trains the horses or?
He's only got one
works
horse
on it?
left. I think he's getting, he
Okay.
probably still wants to race, but he's getting up there in age, so, but he still does have one horse, and I think he still jogs him once a day, but there's not too much racing left.
Happens to the best of us. Okay. All right, anybody else?
And again, it's just if he can get it deeded in his name, he wants to put a pole building there, just kind of improve the site of the property.
Okay, so just so that, as a matter of housekeeping, if we approve the changes, the 197.9, that doesn't mean we're approving
Oh, no, I know,
anything
yeah.
beyond that. That's a
Yeah.
permitting process that you'll have to go through with the county, and
That's
I
no
just
worries.
want to
Yeah,
make
this
that
is just-
clear.
This
Okay.
is just the step. This is the first step in that, and I understand it.
Indeed it
He
is.
understands that as well.
Okay, good. All righty, so that being said, thank you.
Thank you guys so much.
Ms. Denny, could we ask of staff, could the area that measures 197.97 feet, could you Could you designate that or show us right there?
It's actually
Okay.
it's on another slide if you go back, right there. So if you see it labels out as the 219, and I think that's the distance that you would travel on the road. And then I think if you go from point A to point B to point C, which we have written in pencil down bottom, is the 101 plus the 97.97 equals the 197.97 feet.
Thank you.
Thank you so much.
Thank you guys so much.
Thank you, Mr. Miller. Is there anyone else in the room who would like to give testimony in favor of this application? Anyone in the room? Is there anyone online? You can push *3 to raise your hand. Okay, so no one online to give favor. Okay, is there anyone in the room who would like to give testimony in opposition to this application? Opposition? Or online, *3 to raise your hand so we can unmute you. No one online? Okay, there being no more testimony for or against this application, I declare 821-40 public hearing closed.
Next, we have application A-21-41 for Mr. and Mrs. Corbett. This application is they're proposing a variance from the requirement that an accessory structure may not dominate an area, the principal use or structure in order to build a pole building. The present zoning is AC, agriculture conservation, and RS1, single-family residential. The present use is residential, proposed is the same with a pole building. It's in the 6th Levy Court District for Mr. Howe. Located on the east side of South DuPont Highway, about 0.25 miles south of Andrews Lake Road, east of Felton. Here you will see that the dwelling is 2,432 square feet, and the proposed building is a total of 3,200 square feet. The first floor of that building is 2,280 square feet. The attic is proposed to be 792 square feet, and the lean-to of 128 square feet. Here's looking at the home. Down the highway, and in the other direction. This is the approximate location of the building. And again, the home, and the approximate location of the building. And the aerial.
Excuse me, can we get the door closed, please?
Mr. Corbett, if you would like to state your name and address and allow our attorney to swear you in, please.
Good evening, everyone. My name is Roger Corbett, Jr., address 10517 South DuPont Highway, Felton, Delaware, 19943.
Mr. Corbett, so I'm going to swear you in, and you may want to pull that microphone a little bit closer to, there you go.
Okay.
So do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth? So help you God.
So help me God, yes.
Very good.
Okay, being a novice, I greet everyone. Thank you for hearing us today. I like to start out with the response to the criteria, where they had 4 situations where they mentioned that, which is a failure, because we're here to ask that our variance be accepted, and we're here to ask that what we're talking about is the attic space, because the building structure, our home is 2,432 square feet, as you can see up here. And the attic space is 792 square feet, which would put us over the limit for the primary structure. With that being, all we're asking for is space so that we can have proper ventilation. I wrote down, I looked up the CDC requirements for attic space building structures that would reduce spread of COVID. It says pole barn accessory buildings are versatile buildings that can be used in, okay, Attic provides proper air ventilation due to COVID-19 CDC requirements that reduce germs and virus containments. So we also, during this four reasons for denial, the gentleman writes on number 4, he says that unnecessary hardship, exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements in the property. Well, what we did was we went to the pole building. We went to Delmarva Pole Building, and they did us up an appraisal for the same square footage. And if we did the square footage of a building of 780 square feet, it would cost us $20,000 extra. That would be a hardship for us. And to move forward, it says, number 3 says, the proposal may lead to undesirable trend for accessory structures to dominate in the principal structure. We have a contract here that's signed back in April for a solar farm. I have 12.5 acres. I live on a divided highway, and we have a contract for a solar farm here back in April. So we're moving for a solar farm, and we need that attic space, not just for proper air ventilation, but also for storage space. We don't know what we're looking at when this solar farm and equipment comes around. So that we don't have a trend for building more structures because we already have a contract for the rest of the space on the property. So we're just utilizing our opportunity to build a proper and safe and effective building for us and our family for personal reasons, for multiple reasons actually. And number 2, we also have I think that's about all. That's about all of it. I like to submit this. If I did, I don't know if you submit paperwork, but this is the contract, and this is the CDC requirements for building structures for proper CDC spacing regulations and upward airflow up. There we go. And these copies. Yes. Well, just that one, the one contract for the solars, for the solar panel. I'll need that one back. I can come pick it up. Okay. I have a good relationship with Mr. Blair and Ms. Jamie. So yes, I come back and get those because I feel as though, oh, that's the last statement. There was another statement that said that, I believe it was number 2, for the reasons for denial, is that within a half a mile distance that someone was approved for allowing to have the adequate storage square footage added to their building. Well, we're not adjusting the foundation of the building. We just asking for attic space. We're not making it larger, and we're not going anywhere from there because we already have a contract back in April. Every time that we were put in every time we would submit a requirement to build, it would get knocked back for something, and we comply. This is the 3rd time when we comply. They said 100 square feet, we comply. We move back 100 square feet. We're just asking for the opportunity to have a proper, safe building.
Okay. So, essentially, what is the purpose of the pole barn generally? Realizing that, per your testimony, there's going to be, a field of solar collectors. But what is the primary purpose of this building? What's the use for it, or the intended use at this time for it?
Good question. Thank you for asking that. It gives me a chance to relax myself and then speak on. Well, when we first started, I would call Mr. Blair, I called Scott Blair, and I told him we were thinking about just going with not an accessory building, but an agriculture building, because we're going to put a building up, and we're going to do. My wife does seeds, and we make plants. We have a farm, and my wife's family has 100 and something acres. So we have a farming family. That is in Africa, though, I must mention. So we have a farming family, and so she was going to do some of that, and I was going to have an office space, a man cave, and I wrote down a couple of things. Oh, and man cave, storage space, storage of equipment, and we have a lot of church supplies. I have a nonprofit ministry, which I do online. So I would like us, because now, because of all the changes of COVID, everybody has to adapt, just like we're adapting now. So we have an online ministry. It's a YouTube online ministry under my name, Corbett. So we do that. And so we were just hoping that we would be able to adequately and professionally progress our family and progress our community at the same time, because we serve our community. I would be surprised if any of my neighbors would not speak against me. I mean, they come to my home and they ask me, what is this for a pole building? Because, I have a good relationship with my neighbors. So that's what it's basically for. So I was going to do both. I said, I'll just go with the agriculture building. And then I talked with Mr. Blair, and he informed me, if you're going to do anything outside of that, you better just go for accessory. So we did. We had been working this communication out for almost all year now, and I never had to come through this procedure.
Okay, so essentially, you intend to farm this land with the exception of what space is taken up by solar cells. Is that
correct? And they have a program that the company is called YSG that's on that contract, and they have a program where you're allowed to glean some power from the solar. So they're allowed to. They're allowed to. So I don't know how much space they're going to actually need if it gets implemented or not. But for the most part, it's been since April, and it was never an issue to me. It was never an issue to. We didn't think it was an issue to us to have that attic space included with the primary square footage.
okay? So if you didn't use the attic space, how would that work in your world, your business world, if you did not use if it was there but not usable?
If it was there but not usable?
Well, I mean, yes, exactly.
If it was there, we just use it as proper ventilation for the building, because the structures now have to have a airflow from contaminated to uncontaminated, upward mobility airflow, like this building right here, where it reduces COVID-19.
Okay, so at this point, I'm going to let other people ask some questions.
Yeah, I have one. So is this attic space a finished space?
I haven't even gotten that far. We haven't even paid for the steps.
Because I mean, the question.
But that's a good question.
If it's an unfinished space, why? I mean, this is probably for the staff. If it's an unfinished space and it's just for mechanical equipment and just your typical storage, why would that count towards the square footage?
Because the height is over 7 feet in that area.
If he dropped the height down to 6 foot, you wouldn't need a variance?
Correct.
I'm 6 foot. We were thinking maybe if it were to do an adjustment, it would be fair that we can meet in the middle of 10 feet.
Can you speak to me again about your hardship, the 20K right here?
Okay, sorry. For the hardship for...
Yeah, you mentioned it was a hardship of $20,000. Can you repeat that for me, please?
Yes, thank you for asking. What we did was we did some homework and we looked into how much it would cost for us to supplement this if unfortunately we were denied. And to supplement it will cost us over $20,000 for 700 square feet. Just a small square feet would cost us over $20,000 some dollars. And in the denial letter, it says that we're setting up a trend to continue to build buildings. And they just pretty much don't know me. We're setting up a trend, yes, to better ourselves and our community and our family. But we're not building other buildings because we already have a contract for a solar farm.
So the trend they're talking about, sir, is not you, it's whether your experience would then bleed over into neighboring properties who could feel they don't have to comply with the ordinance because you weren't required to. That's what the trend is they're referring to, I think.
Understandable. Thank you.
So essentially, as we are considering the variance, we look at it as, is there an exceptional practical difficulty related to your property specifically that would cause us to decide in your favor, that in order to not set a precedence and not have everybody on locally come in and say, well, he did it. We have to find a specific exceptional practical difficulty. So that said, now I have another question. Does anybody have questions?
Yes,
Go ahead.
I do. In regards to the pole building, that I thought you gave us a price. You said Delmarva, you got an estimate from them, and it would cost $20,000 to build an 800 square foot facility. Is that correct?
Yes, yes, sir. It's from them. Delmarva Pole Building is the ones that's doing our pole building. So yes, they did that for us too.
So do you have that quote or estimate with you?
Yes, the gentleman picked it up.
And another question on the pole building size itself, the 38 by 60, that's 2280. Why so aggressive? Why so large? Was that just an arbitrary number, or what was your basis for 2280?
Well, we weren't looking at it as aggressive. We were just, in our mindset, we were just trying to be compliant to smaller than the actual structure. And what happened was we never considered, we were told by Delmarva Pole Building that the attic space wouldn't be included in the square footage. And even as we proposed our proposals the first time, the second time, it was never an issue until this third time. So that kind of caught us off guard about that size. But the only reason that we needed that space is because we knew that that was pretty much it, because we had the contract and that was it. If we get an accessory building, this is the maximum that we can do.
So if the 792 square foot for attic space was not approved by us, what would your game plan be?
Prayer? I haven't considered that. I didn't, I am pretty much an optimistic person. I'm actually a veteran. I'm a 9-year disabled war veteran. And I actually always I'm always optimistic about the situation. So I haven't thought that far, so unfortunately.
Well, I'm just saying my responsibility is to try to uphold the Kent County Code. And the reason I'm asking the way that I am is we wouldn't want that trend to be indicative of your particular building and the structure, the size that you're attempting to build. And it could look that way from neighbors if we approved this and didn't consider everything, that we could be opening up a can of worms. So
I understand that, sir.
that's the reason for asking.
Thank you.
Anybody else with questions? Mr. Townsend?
Thank you. I have a question. Maybe it's for staff, but if this building were relocated behind the residence, would that alleviate the problem, or no?
No.
It's purely the size of the building, and it doesn't matter where it's located at all.
Correct.
Under the code. Okay.
Okay, so I just have one more. So at this point, you have no intentions for this building for anything other than agricultural storage,
Oh, yes.
possibly agricultural equipment, but storage.
And for our online ministry, yes.
And
We have a lot of storage. We have a lot of church supplies. We assist other churches. We help the church in Dover on Governor's Avenue with church benches, and it's just what we do.
So you're not planning on holding services there. You're just storing things that you might need for your other churches, and you're going to have possibly, as you're describing this to me, my interpretation, and you need to correct me if I'm wrong, is that you may have an office in there so that you can do online services or work with your congregation.
Madam Speaker, I'm sorry if I said that right, Madam Speaker. What I'm saying is, when we set up our online ministry, I mean, that's, we do that through the computer, and it's our family and friends. I mean, that's considered church. I mean, when we pray and open up the Bible, it's considered church. I'm just saying, because what we have right now is what we have right now. And, we swear on the Bible here. So it's our building. We would like to think it's our building, if the process goes forward, and do our online ministry. So that's online ministry. That's, you can, like I said, we can look on the internet and see us now. I was raised in Catholic school. I was an altar boy. I shook the Pope's hand, Pope John Paul II's hand. This is what my calling is, and this is my passion. So in the office is not just going to be the office is separate from setting up like a podium and the camera, just as everyone is doing right now, is adjusting because of COVID-19.
Okay, so I'm understanding then that you are going to have a service there with yourself, but the congregation will be viewing online. They will not be present in your building other than in here.
Family and friends.
Well, okay, so when you say family and friends, now I'm thinking how many people, friends?
Let's see, eight.
Oh, okay, all right.
I mean, we're not large like that.
Okay.
We don't have any mega church or anything like that. I come out of a church.
Okay.
And I'm just I'm not just, but I'm an elder. And I was, like I said, this is my passion. This is just what we do.
I understand. Okay. Anybody else?
Yes, I have one last question. It's in regards to the storage.
Yes, sir.
So what are you, if you don't mind me asking, what are you currently doing to address the storage needs that you're going to take care of if this was approved?
Well, if you look right now, there is like a storage building behind on Mr. Killen's property, right back there. You see that long chicken house right there? You see that long chicken house?
Yes.
Okay, so he allowed me to put some stuff in there. I have stuff in there, and he's waiting for me to take it out.
Do you have any idea what the dimensions are of that building, by chance?
It's not on my property. I know it's huge. It's an old chicken. If anyone has been out there, they've seen the building. He's my neighbor. Like I said, I have a good relationship with my neighbors, and so he allows us to put some stuff in there until I get the building up to get it out. It's been in there for 3 years.
Okay, so when it's not storing your furniture, is it an active chicken house, or is it just at this point vacant? It's not used.
No, he uses it.
He uses it.
Yes.
When?
All the time.
Okay.
Because he farms my property also.
Okay.
Right now we have barley on there, and this year we did mostly soybean.
Okay. Anybody else? All righty, I think that's it for us.
I appreciate being here. It was a privilege to be able to speak before you. Thank you for having me.
You're welcome, and thank you for your service.
Thank you.
Is there anyone that would like to speak in favor of this application? If there's anyone on the phone, please press *3 to raise your hand or *6 to unmute your phone.
I see no hands raised on WebEx.
Thank you. Is there anyone here that would like to speak in opposition of this application? Thank you. Please come forward and state your name and address and allow our attorney to swear you in.
My name is Susan Webster. I live at 10444 South DuPont Highway, across the road from the dealership.
Ms. Webster,
Yes,
do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Do I speak now?
Yeah, but at this point, you
Okay.
tell us what your objection is.
Okay, I do have objections to a big building across from my house. So far, I have a dealership to look at, and a massive building across from my house would be absolutely horrible. It would lower the value of my home. There is no doubt. And as far as I see, I've heard nothing about the power thing. I'm sorry, I'm weak.
That's okay. Take your time, because I can tell you're struggling to breathe here as you're speaking.
So, was it solar panels?
Solar panels?
Yes, solar
Yeah.
panels.
Okay.
I've heard nothing about those, but I've seen the church sign outside, and my thoughts are that the building is for a church, and I do object to being, I object to having all the extra traffic and commotion going on, because it's not fair on the other neighbors. And like was said, if there's one big building going up, there's going to be more. And I love Delaware, and I don't want to see it run into the ground like I've seen in New Jersey. So that's all I have to say. But I do object to a big church going up.
Okay, so the planners are here, and I want to assure you that this application is not to have a church there. In the event that there was movement towards having a church, it would be necessary for them to come back and actually go through not only us, but they would go through a higher committee than we are, and then possibly have to come to us for variances in order to get through to that committee. That's a totally separate application, and it requires a lot more planning. So at this point...
But the larger building I do object to too. You know, the monster
the
building.
pole barn. But I just want to assure you that there's this application, and that's why I questioned him about, about how many people, because specifically this application is not for a building that can be used as a church. Okay, just
okay.
to take that worry from you. That's not what this application is about.
All right.
And it would require, and you as a neighbor would be notified, because her property is within the proximity of legal notification, like you knew
Yes, I got
in
the
the sign.
paperwork, yes.
So I just want to assure you that that is not what this application is about. I do understand that aside from that, you are objecting to the size of the building.
Yes, I
And I
am,
get
ma'am.
that. Okay. All right. Anybody else?
Yes, I have two questions.
Go right ahead.
One, is there any way that we can point out the witness's house in relationship to the parcel where her house is, or her
I
lot?
can show you. Can I come across?
You may come show us. You can't give us testimony at this point. You'll have a
I'm her
chance to
son.
speak if you choose.
Just
Okay.
making sure she's okay.
Make sure she comes. Okay.
Mom? Mother? Yeah, it's, if you look right up here, there's a gray house, there's a brown, gray roof right there where the arrow is.
I had a second follow-up question.
What?
Yes, in your testimony, you objected to the building, and I think you commented that you thought if this building is built, other buildings would be forthcoming. Are you talking about additional buildings on this parcel, or just additional?
Just in the general area, because it opens up a bag of worms, doesn't it? You let one person do it, you have to let another person do it.
Okay, thank you.
You understand what I'm saying?
Yes.
Yes, but what I would like for you to understand, the whole reason for this committee and the way Kent County's code is set up is that you can apply for a variance, as the Corbetts have done, and come before a hearing like us, and we have to find an exceptional practical difficulty that makes their property eligible for this. If not, so essentially, we are not setting a precedence. And generally, when I vote, you will hear me announce that almost every vote. We're not setting a precedence that just everybody can just do what he did. There would be a hearing, they'd have to have reasoning for us to make a change or allow for a variance from the code. So just because one building goes up doesn't mean like all the neighbors can do that. And I want to assure you that there would be hearings based on each individual application as they came. So I also want to comfort that fear to a certain extent. Doesn't mean somebody can't come apply, but they would have to come, if they had such a building in this way, they would have to come before us for a variance. Okay, so it's just not automatic. If we say yes to this, everybody gets to put one up. Okay?
Okay.
Anybody else? I think we're good. Thank you.
Is there anyone else that would like to speak in opposition of this application? If you're on the phone, please press *3 to raise your hand.
No one in opposition online.
Seeing no more in opposition, this application's public hearing is now closed. Next, we have application A-21-42. This is for the applicants Kent and Farron Brown. The present zoning is AR, agriculture residential. The proposed variance is a variance from the required 25% maximum impervious surface coverage to legalize the existing impervious surface coverage on the property. The present use is residential. Proposed use is residential. It's in the 5th Levy Court District for Mr. Sweeney, located on the north side of Fence Post Lane, approximately 483 feet southeast of Turkey Point Road, north of Viola. Here you will see that the current lot is 21,780 square feet. The existing impervious coverage on the property is 8,850 square feet, equaling 40.6%, and the permitted impervious is 5,445 square feet, 25%. Here's a look at the front of the property, down fence post, in the other location, the other way on the road. This is the driveway and the outbuilding on the property. More of the asphalt and the accessory building. More asphalt. This is stone in the backyard and the aerial. If someone would like to come forward and present the case, state your name and address for the record and allow our attorney to swear you in, please.
I am Theron Brown, excuse me, and I'm at 647 Fence Post Lane, Viola, and that's 19979.
Ms. Brown, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Absolutely do.
And if you would, please pull the microphone down towards
Sure.
your face.
Can I take this down to talk, or is it yes, no?
I'd ask that you leave your mask on because the person who comes after you, if you take your mask down,
good.
will have a microphone that you have breathed on.
I get it, totally. Okay. All right, so I'm just gonna, I know this is our second time here, but I know that I'm supposed to, it's all fresh. Correct? That's the approach to take?
Right, you begin at the beginning.
Okay, all right, so we'll do that. All right, so what we're here for is to seek variance for our impervious surface overage. Okay, the question I have kind of is more of why. So here it is. I was born and raised in Kent County, and I must say apologetically that this is something I was oblivious to. Even before we made any decisions and took any step to prepare.
Can I ask you to speak just a little more slowly, just for my understanding, plus we're making a recording.
Sure, not to mention
That's
the
okay.
mask and stuff, so I'll do my best. Okay, so even before we made any decisions, we took every step to prepare. In these preparations, I called the permitting office multiple times regarding the process and our plan. On one occasion, we asked how close to the property line we could pour our asphalt. This was in an effort to make a clear line between properties. Unfortunately, our neighbor we've had issues in that respect, but in this call, I was told to pour up to the line, no problem. For this reason, we paved an extra 3-foot strip of grass along the property line to, in fact, create a clear boundary between our house and the neighbors. On another occasion, I called to confirm that no permit was needed, especially considering the extra area. I was told not from Kent County, but that I'd need to contact DelDOT, so that's exactly what I did, and I was given the go-ahead. I was asked if I knew who I talked to, and unfortunately, with such clear answers, it seemed unnecessary and lesson learned. And all this counsel, and even with well-respected contractors, no one mentioned anything referring to the potential impervious overage. Ultimately, we just didn't know. However, when we were made aware, we quickly took accountability of the overage and made every attempt to make it right for our neighbors and the environment. Up to today, that I have talked to many Kent County, many people affiliated with Kent County and members, and to reveal that the origin of this is purely civil. And so that is kind of my presence of where I am. My husband's going to come up and talk more about some of the things that we've researched and found out along the way. But
I have a question.
Go ahead.
Did you pour the concrete or the asphalt yourself, or did you hire a contractor?
Oh, a contractor. Yeah, and again, even we reached out to them, and it was news to them as well.
Do they normally do driveways in your area in Delaware?
Yes, they do, absolutely. And I mean, it's very much that he said, if you're going to do anything, you need to contact DelDOT. It was on the contract that, permitting is required from DelDOT for driveways, but typically that's new. Driveways are expanded of something about ours. Like I said, we got the clear to go with DelDOT.
Thank you.
I had one question. So I see a letter here from Kent Conservation District.
Oh, gosh. Look, I got other stuff for
from
you,
Jared
too.
Atkins. So it looks like you did your due diligence, contacted them, and they gave you the no objection to increase impervious coverage.
Yes, and I actually have more information for you guys, too. To back up what you just said, we took it one step farther than the letter of no objection from KCD, because he suggested no objection. However, no physical studies were done on the property by him. He does his large aerial and determines it that way. However, we contacted a environmental service. I'm pretty sure my husband's going to touch on this too, and revealed that there is that our property has fantastic soil drainage and will accompany a full depth gravity system. So there's literally no water issues on our property and drains very well. So I have some more. Do you want me to hand it out or just bring it up?
I also just want to add for the record that Ms. Brown has submitted 2 letters of in favor and support of her application, and those were forwarded to you by email. They came after the staff reports were sent.
I do believe one of those letters is actually in that packet, just in case.
I think in the pictures, Jamie, there's a fence. Is that the neighbor's fence or is that your guys' fence?
Okay, so that fence right there
Yep.
is actually was put up the day, just a couple days after the driveway was done, by my neighbor's husband and another person. So the posts were not in; they were hand dug and not adequately backfilled. Sorry, I got sideways. So they're, it's if you look at it, it's crooked. I mean, it's fine. It's not that much of an eyesore to us, but definitely a spite fence.
So what you're saying is definitely it's your fence?
No.
Oh, a spite fence.
Spite, yeah.
Okay.
Yes.
So, in relation to the last time you were here, have you done anything to resolve the drainage issue that on your neighbor's property?
So, because I disagree with the fact that there was drainage issue, and we reached out to the environmentalist to confirm, and I also recorded a bunch of video, a few clips, and unfortunately, your system didn't allow for, I don't know, they just didn't connect. I forget what you actually said.
Sorry, Farron. This is Fred. Don't we have to treat this as we've never heard the other one?
The record today should be what you rely on to make the case. However, if the applicant wants to speak to something that occurred in the past, I think the applicant can do that, even though it was a hearing that we had held. Now, we don't need to hear hearsay accounts of what other witnesses may have said or didn't say at another hearing. So I would add that qualification.
So essentially, you don't have to answer the question if you choose not to.
Okay. I actually don't even remember the question at this point. So did I actually answer it? I feel like I did. I didn't. What was your question? Can you repeat it?
I had asked you about if you had done anything about your neighbor's drainage, and you don't have to answer that question.
Oh, okay.
Anybody else? Mr. Townsend.
Could you speak though to the need for the pavement? I mean,
yes, absolutely.
Why do you need to exceed the impervious surface limitation?
Absolutely. Yeah. So honestly, the only additional pavement that we have on this property is literally that it's 3 feet. Our driveway did come out a little bit past the shop originally. It's about 3 feet from where that fence is now, all the way back. Other than that, it was our original driveway. However, it was stone and poorly graded, so we were upgrading the property and the aesthetics of the neighborhood. Excuse me. The back area was always muddy and had awful drainage issues there. So we opted to pave it and have a basketball court where the neighbors and everyone actually are able to have a rec area. The road, I don't know if you guys are familiar with fence posts, but it's a cutoff road and people just zoom by it. So the main street is not a place to hang out. So anyway, that's definitely what the back section is for, that we increased.
So you paved it in order to improve drainage?
Okay, so it was always muddy, and we couldn't go back there. You couldn't enjoy the property. And then when it was packed and graded properly, and for aesthetics, we were either going to do this or put the blacks. Millings, thank you, babe. Millings back there, but because it was more money, but aesthetically it just looked better to go ahead and do the whole back. And you can't play basketball on Millings, or ride your scooter back there, or ride your bike, or roller skate, whatever the kids are doing. The neighbors literally, we all can be back there and do that.
So the additional pavement is a widening of the driveway by 3 feet. Were you running the pavement along that backside or that side of the garage along the fence? Is that new?
So there was no pavement on our property prior to us having it installed.
Oh, okay, all right.
But there were the stones in the driveway was back to the pole barn, like back that way. I will note that I know that originally and it's in the packet, the pavers in the back, I don't know, one of the pictures shows that we have a little patio back there, yeah. It's a little bit questionable. I know that some people assume quickly that it's impervious, others say pervious, but I did want to note that there are large gaps. It's not a solid surface. So some people, and even you can see vegetation growth, which is the goal, is actually to have some of that. It's actually a little unappealing in the picture, but yeah, there's 6 inches or more between some of those cracks. So I hate to assume that seems like another solid surface, but again, that's another, it's assumed either way. Yeah.
Have you noticed any water issues on the neighbor's property along that fence?
No, never actually. I even took pictures. The pictures that you see in there are the most recent. With it looks like fall, and the fact that leaves and stuff are around, and it's just always dry. And if anyone had an issue, it would be the back property where you see that tree line on one of the pictures with their cypress trees. It does slope that way to those trees in an effort for runoff. And those trees' roots do a really good job of absorbing the water. And our neighbor has 0 issues behind us. And note that the complaint came, from an angry neighbor. So, who lives literally, her residence is probably 400 feet from our house. We just live on one of those, it's no longer even approved dividing of land, that she lives like literally 3 houses behind us. And we only share that small fence that's only on our property. That's it. That's all we share.
I would advise the board that it's not relevant where the complaint came from or how the non-compliant circumstances came to be known by the county.
Do you have something?
Yes, I do. There's an attachment. There's an attachment to your application. And on this attachment, under comment number 3, you got, furthermore, the asphalt is porous in nature and visibly absorbs water. Is this some unique type?
No, it is. No, it's not. The stones are larger on it. It's still it's a high quality tops coat, or I think it's not coated like a lot of people seal and coat their driveways. So it literally, we even have a downspout that goes down, and it literally, a lot of the times it goes in this, especially in this one place, you can see it like just kind of bubbling through the asphalt, not just like running. And I tried to get some of that stuff on video, but like I said, it wasn't compatible.
And just to follow up, you have there's also an application on your behalf from Martha Rose, 635 Fence Post Lane. She's in support of this.
Yes, Martha is the one that I just spoke of. That's literally right behind. We see that row of trees in the back. They're large cypress, not cypress. They're Leland cypress, And her house is literally the one right behind our house.
Okay.
Yep, that's the one.
Anybody else? So I just want to state for the record, as a matter of housekeeping, that the planners have still recommended denial of your application, and based on the amount of macadam that's there. That's
Yes, I understand. I mean, honestly, we are very compliant. So the fact that, we did our due diligence and we tried to reach out, we tried to get answers, and we got go ahead, and that's why we're here.
Did you get a quote for how much it would cost to have it ripped up?
I did not get a quote for that. I don't know if my husband did. We definitely were, it was thousands. But I think that maybe I'll let him talk on that.
What's a ballpark number?
I think it was over 5,000 to get something like that was where we were landing. And I know that the shed too, it's removable. It's my daughter's playhouse. It's a shed, but it's her playhouse. So, I mean, ultimately I could put that on top of part of the asphalt and create, at least a couple hundred. I mean, it's not like a huge amount, but I'm just saying there's just definitely, and it would leave with us if we ever moved.
So you would be willing to move it over to the asphalt to give more impervious?
I mean, it would be something to consider. However, that would take away the whole piece of them having an area to play instead of playing on the busy street.
Anybody else?
Just to follow up on that last statement, so that playhouse is trivial in relationship to square footage,
right,
when you look at the whole bigger picture.
Absolutely.
Looks like that's it. Thank you.
Thank you.
Sir, if you just would like to state your name and address for the record and allow our attorney to swear you in, please.
Kent Brown, 647 Fence Post Lane, Biola, Delaware, 19979.
Mr. Brown, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Absolutely. Okay, so I feel like we've got most everything covered. Something I wanted to bring up is, Mr. Townsend, you mentioned that we should not discuss neighbors' complaints, etc. And that's fine. You can stop me, but that's where this started. And I want to bring something to the table. A couple things. We did this without an awareness of a code. Okay, so there's a piece that I feel like we're being punished for not being aware of something. Okay, so to start with, it's my opinion that if this is such a severe issue, that perhaps there should be a different permitting process to ever even install asphalt. Okay? We did our due diligence. We contacted the permitting office. We contacted the state. We did everything that we knew to do. Okay? I realize now that we have exceeded an allowance, and you guys, it's your responsibility to filter that and make sure that a code is followed and that a precedent is not set. I'm all for that. One thing that has happened in this process is we've created an awareness in our community that there is a code for an impervious surface allowance. Everyone up and down our street is now aware that you can't just pour asphalt without finding out what your allowance is. So if there's a concern that a precedent's going to be set, I don't think that there should be, at least in our neighborhood. There are no additional homes that are going to be built in that area. It's an established area. So, that's my thought on that. We did hire a reputable contractor to install the asphalt, and as Farron mentioned, they exclude any responsibility for permitting, and we agreed to that. I feel like a contractor in that field should have been aware of that and perhaps shared that. That's that's just a thought that could be visited later on for asphalt contractors. If this is that serious of an issue. The second thing is we're relying on the professionals in this field. Kent Conservation. I reached out to Jared Atkins, and I received a letter of no objection. Had I received something from Jared stating, Kent, you guys really screwed up, and this is going to be hazardous to the environment. You really need to comply with this and get that removed because this is a serious issue. I would have gotten it taken care of right away. However, he said it was fine. I have a letter from Jared stating this is not an issue. This is not a problem. This is not an environmental concern. This isn't a drainage concern. So we had that piece, and that's what I want to rely on, not a subjective opinion of neighbors, etc. Although we have most neighbors are in favor. Additionally, I spoke with the individual who created this complaint today. I called her, and I said, Tony, what is your major issue? What can we do?
So I'm afraid we're getting into an area here that is really not relevant for this group.
I understand. The main concern for any type of drainage is one downspout. And I have agreed to turn that downspout in the direction that it will run to the back of the property versus, and if you want to show the fence. So that downspout, back up one. That downspout, I have agreed to turn it and run it the other direction to where it will not drain toward the grass, where there is, a complaint, if you will. So as far as, I made a note when Mr. Townsend said, referring to number 3, and if I understood it correctly, it's, seriously affect neighboring properties. And this does not seriously affect neighboring properties. As we have signatures from all, and we have letters, I believe, from 2. And the fourth item, would it create a hardship? Absolutely. And, $5,000 plus to remove asphalt in an effort to comply with a code that we were unaware of.
Anybody have any questions? Thank you.
Thank you.
Is there anyone else that would like to speak in favor of this application? Please state your name and address for the record and allow our attorney to swear you in.
My name is Tyler Anaya. My address is 103 East Howard Street, Viola, Delaware, 19979.
Ms. Anaya, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. So, first of all, I hate speaking in front of people, so I'm sorry. I wanted to actually come in support of Farron and Kent just because one of the things that they said, they did their due diligence. I used, as you guys know, used to work for the planning office, used to work with you guys. You're on the board as the planning staff. They actually called me, and I was one of the people that they referred to and said, hey, we're getting ready to expand our driveway. What do we need to do? And I also used to work for the permits office. So I said, you know, the one thing about it is that you have a regulatory agency that is Kent Conservation. You have a regulatory agency that is DelDOT. DelDOT is going to be the main driving factor. They said, do I need to call Kent County Permits Office? And I said, no, they don't issue permits for that. But call them anyway. Just to say you made that call them anyway. So they actually, I feel awful because this is something that we actually went in depth talking about the different things that they should think about before, you know, getting this permit for the driveway. And they went and they got the driveway because everybody said it was okay. So whether it was the left hand or the right hand that didn't communicate, I feel like Kent kind of spoke to that a little bit where, you know, working for Kent County, you have to use aerials and you have to see what's there. And if we don't have updated pictures, then you can only see back what's actually there based on the last pictures that were taken. So there was probably a disconnect on that one. But from sitting where you guys are sitting, one of the things that I heard a lot from him was, oh my God, I didn't know. And I said, you're not alone. You know, that's one of the things that unfortunately a lot of people don't know what the code is and don't know what their allowance is. One of the things that I advised them to do, and I told them, call Jared Atkins. He's great. He works at Kent Conservation District. He actually he's kind of like the engineering guru. And I said, you know, ask him if there's any kind of mitigation. Ask him if there are any kind of rain barrels that you can do. Can you do any kind of runoff help to say that this is something that we can do? And he said, nothing's needed. I don't do a study on something until we're at least 50%. So from talking with him in the past, the things that he would say in regards to excessive impervious surface coverage is, when you look at it in the grand scheme of things, he would kind of say, if you're looking zoomed in on an aerial map, you know, we have like 10 houses that are kind of smaller than the typical house in this area. I have an acre. We have a 20-acre farm right behind us. So, and that's my family's. So the typical residence in this area is not half acre, half acre, half acre. We have the typical area, which is very rural. Even though we are inside of the growth zone, it's definitely not highly developed by any means. So when he says you zoom out, I look at things on a bigger factor. If there were an issue with stuff in the grand scheme of things, I would be concerned. I'm not here. And I have seen letters of no objection from him before, and I've also seen letters of suggestion from him before saying, this is what we expect to do. And I've seen them in subdivisions where, you know, it can create issues with the whole grand scheme of the subdivision drainage. So I wanted to kind of touch on that because I think that was one of the disconnects, unfortunately. They do have, I know them very well, and they do have a family that they have younger children and older children, and they're always outside. So the fact that they have kids that are different ages, they have multiple cars because now we've got driving age kids. We've also got younger ones that like to play outside. So, and as far as like the nature of the zone, again, kind of speaking to this, I did the calculations. If they were on a typical lot size in our community for 1 acre, they would have less than 21% coverage. So it came out to be like 20.6 or 20.8. So again, thinking about the exceptional practical difficulty, if they had a different house that they had started with, but that wasn't, they moved into a family home. So that was what they were given and that's what they have to work with. And if you drive by their house and you look at it, there's nothing outside of the norm. They have a pole building, they have a house, beautifully maintained. They have a shed out in the backyard and a little patio. So in the grand scheme of things, I just wanted to show my support for them because it's my neighborhood and it is pretty to look at. And we do have some that are not so pretty.
So in any time in mostly with your expertise, did you, when they were telling you about this, did you enlighten them about impervious soil?
We actually, when we talked about it, I asked what they currently had and I said, how much are you expanding? And then I said, make sure you double check with Kent County to make sure that everything's okay. So no, I did not say, oh, you only have X amount of coverage, because as driving by their house, if you're looking at it, it doesn't look outside of the norm. So that would be something like I've encountered houses that are in different developments where you can tell like, oh my God, that's definitely over their coverage. This is a situation where I didn't ever feel like it was super excessive by driving by it. I mean, you can't see behind that building, and that's one of the things from the street you can't really. So no, I never specifically said impervious surface coverage is this amount, but I always said, make sure you double check with these agencies.
Anybody else? Thank you.
Thanks.
Is there anyone else that would like to speak in favor of this application? If you're on the phone, please press star 3 to raise your hand.
No hands in favor online at this time.
Thank you. Is there anyone that would like to speak in opposition of this application? If you're on the phone, again, please press star 3.
No hands in opposition online.
Seeing no one, we will close the public hearing for application A-21-42.
Okay, the next and final application for the night is A21-43. Do we have someone here to represent the application? Thank you. We'll call you up after the kind of introduction. So again, this is A21-43. Daniel A. Burrows, he's seeking a variance from the 10-foot side setback requirement to legalize the placement of an existing deck. The property is located on the east side of North Bay Drive, 540 feet north of Kitts Hummock Road, east of Dover, Levy Court District 3rd, and it's zoned AR. So this is just a schematic of the deck in question and how close it is to the property line. These are photographs of the house in question. You can kind of see the deck. There's better photographs later. Thank you, Jamie. This is looking up the street, and this is the other direction looking down the street. This kind of gives an idea of where the neighbor's house is in proximity to this, and gives you some idea of the property line. And this is the actual deck in question, and you can see the proximity to the neighbor's house. And this one kind of gives you an idea. You saw from the previous schematic, I believe it was 6 inches or so from the property line. You could imagine that kind of moving along there next to the deck is where the property line is. This is an aerial photograph, and this is a higher up aerial photograph of the property. Okay, if you'd like to come up, Mr. Burrows, and present your application, please, just let our attorney swear you in.
Name and address, please, Mr.
I'm
Burrows.
sorry. My name is Dan Burrows, 104 North Bay Drive.
Mr. Burrows, do you solemnly swear upon the Holy Bible the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do so swear. Good evening. My name is Dan Burrows. With me tonight are several of my wonderful neighbors from Kitts Hummock. I'm going to demonstrate that my request is in keeping with the community, that my neighbors support it, and that without it there is a significant hardship. Some brief history on Kitts Hummock. I hope each of you are perhaps familiar with Kitts Hummock, a bayfront community. Around 1975, the community went from being a large rental neighborhood. One family owned it named Huseman, and they had lots of houses all over the property. It was one big parcel. And what you did was you bought your house, but you leased the land. The Huseman family was your landlord. Around 1975, the patriarch of the family died, and the family didn't want to be in the business anymore. They wanted to cash in. So they divided up all the lots. That was done with county coordination, the family, and legal surveyors. My lot was made what it is in 1975. I have here just a few days ago, this was given to me by my neighbor, Andy Mariani. This is the survey he received around 1976 or so when he bought his house. I merely want to point it out to you and pass it along, if I may, because it shows my house and his. And on the side of my house, there's a porch sticking off that's not there today. That becomes relevant later on, which is why I want to point it out now. May I bring this forward?
Yeah, we'll send somebody to get it.
Okay. He's going to be busy tonight because I got a lot to bring forward.
Mr. Bursky, may we have these in a minute? Are they originals you need back?
I'm going to need that one back or Andy will beat me up.
Okay, that's fine. I won't stand.
And he can do it. He's retired Air Force. Please take a look at that. I had it folded up in such a manner that the last two houses on the far left, one of them, the second one says Mariani. That's Andy. Andy's been there a long time. The other house right next to it is mine. There you go. This is the whole neighborhood on here. The only two we're concerned about are the last two, mine and Andy's. You will note on mine a large porch sticking off the side of the house. That becomes relevant later. Mine is the very last one all the way over on the left, and there's a porch sticking off the side. Thank you. The other thing I'd like to point out to you, in addition to that survey and the porch, which is relevant later, is the map provided to you by the planning department. If each of you look at that, or we put it on the screen, you will take notice that Kitsummik, practically all the lots in the entire community are non-conforming. Anything you want to do down there requires a variance, which is why we're here tonight. More importantly, take notice of my lot. It says subject lot, subject site. It's the skinniest, tiniest lot in the whole neighborhood. I got it the toughest. I wanted to point that out to you. It's why I need a variance. These surveys, this layout of the neighborhood was created 50 years ago. You'll also notice in my application, I provided a summary of what my case is. Practically everything in here is what I'm now going to talk about. If you have to refer to any of this later, this sums it all up. I'm going to talk now about the actual survey, which you also have, my property survey. And I've kind of transferred it. I'm not a great drawer, and I will need to, if you don't mind, stand away from the mic in order to point to some things. Let me try this. I understand the need to get this recorded. Okay. There we go. I can work with that. I want to point out that on the right side of my home, I have only 3 feet. I'm good, thank you. That'd probably be tougher for me. On the left side of my home, I have only 6 feet. I can't meet the 10-foot variance no matter what I do. My lot is only 35 feet wide at the front. The left line stays straight, but the right line slowly comes in. When you get to the back, I've got 25 feet. Here at the front, the first 15 feet is Del Dot easement. You'll notice that's my driveway, and that's all I got. It's the only place I can park. I cannot get my vehicle around to the back or anything. This is all I have. I think from the survey and this drawing, you probably get the point. In 1930, this part of the house is what's original. And in 1975 and 77, these additions were added. I have copies of the permits here for those provided to me by Scott Tanner. It was during this period when these additions were put on that the porch that I referenced earlier disappeared. It became incorporated as part of the inside of the house. You've seen that where these old 1930 houses have a front porch and later on they enclose them and make them part of the house. Well, that's what happened here. So I wanted to get this big picture to you and see how tight it is, 3 foot and 6 foot, and very limited parking space. To show you the parking situation, I have some photos here I just took, and I'd like to pass these along. You can see my actual vehicle, only two, it's all you can fit in there, mine and my wife's. You can see our vehicles in the driveway, and while they're sitting there, there's no other space. And that's where this whole issue comes in. There's a statement that there was a front door on there and I removed it and all this good stuff, and we're going to get to that. I want to show you the front of the house and the parking situation, and I'd like to give these to you if I may. Shall I?
Different pictures than what we have in our package?
Yes, I think they are. Okay, I'm sorry, you do have some. Okay, if you wouldn't mind, just refer to those photos, and you can see what limited space there is. So with the history of the community in mind, the fact it was all laid out and surveyed as it is today, 50 years ago, mine's the tightest in the community. I have very limited parking spaces. I bought this 3 years ago. When I came here 3 years ago from Newcastle County, I've lived there all my life. I was seldom in Kent County. I bought down here at Kitsummick 3 years ago. In Newcastle County, where I've lived all my life, I've owned a lot of houses, you do not pull permits for windows, sidings, and doors. You don't pull them. So I bought this house, and I did not pull permits 3 years ago for windows, siding, and doors. I don't think you have these, and I'd like to pass them on. This is how the house looked on the day I went to settlement, and it will demonstrate to you the condition of this home. I want you to pay particular attention to everything here and note that when I bought the house, this is how it looked. You may keep those. And there were no violations. County was doing nothing about it. I certainly didn't think cleaning all that up, it's a complete mess, wait till you see it, and doing windows and siding and doors was an issue. I thought it's a good thing. I basically got it completely done, all the windows, the siding, and the door, and was actively starting to build the little boardwalk that we're talking about here when a code enforcement officer showed up, Brian Reed. On that day, Brian Reed took a picture of the front of the house. This is the picture, and it was provided to me by Scott Tanner about 2 or 3 weeks ago. You may have this in your folder. What's important to note there is the front door is not there, but the busted up steps, the remnants of an old door, were there. He saw that on that day. He told me, "Sir, you have to pull permits for windows and siding and doors down here at Kent County." I said, "I did not know that. What do I need to do? You let me know, I'll take care of it." It was then I got the bad news of something I did not know about. It was called the FEMA 50/50 Substantial Improvement Rule. And once it got explained to me, I became very concerned. I thought, wow, this could be tough. And I had already put a lot of money into it, but I got through it. I had to get an appraisal done. All this went through Mr. Tanner and Mr. Reed, and I pulled permits, windows, siding, and doors. The inspector, and I was actively doing the boardwalk on the side. I call it a boardwalk, not a sidewalk. I also don't call it a deck. I call it a landing. It's not that big. There's not enough room there for furniture or a grill or some fun. It's a landing to get in my door. I didn't know 4x4 is what it's supposed to be. This one's like 5x7. I wanted to be able to allow my mother, my father, my mother and father-in-law, all of whom are about 90 and walk with walkers and so on, to be able to come in the house, maybe with them. 4x4 doesn't work, especially to swing the door open. So I got through the permit process and the appraisal in the 50/50 3 years ago. An inspector came around and looked at everything, including the boardwalk and the landing. Everything was okay, and the permit was closed. Now, 3 years later, this has come back to me, and it's strictly about the landing and the boardwalk. As I understand it, boardwalks and sidewalks don't need permits. It's the landing they really have an issue with. And they also, according to the planning department's letter of objection, they have an issue that I changed the door. This is simply not the case, and I have some evidence to help prove that. The first piece of evidence is the 1975 survey with this porch sticking off the side. You can now see today the side of that house is all straight. There's no porch because the porch got incorporated into the two additions that were done in 1975 and 1977, one on the front, one on the back. So the door was there on that side, but there was also one on the front when we bought the house. I would like to show that picture to you. I hope I can find it here. I apologize. Now, I'm going to try to find it perhaps in a moment. I have a picture. Here it is. This was given to me by Scott Tanner a few weeks ago. I went in and basically said, I want to see everything that's in the file. This was taken in 2015 and was right there in their office. That's 3 years before I bought the house. It shows the front door. When I bought it in 2018, did the windows and sidings and doors, and then got told I've committed a violation, which I willingly corrected. The code enforcement officer took a picture that day. That's the picture I sent around. It shows no front door, and it shows the steps all busted up. And then they came back to close the permit, and they walked on that very deck, on that very landing and boardwalk, and they checked everything out, and they closed the permit. My point is that 3 years ago, when he took this picture, in his exact same file here, he had a 2015 photo with the door. Why is it 3 years later the door's an issue? They're now claiming you moved the door. No, here it is the day you took the picture. They're claiming I created the door on that side. I did not. That door was part of a previous porch that got enclosed. That survey from 75 helps to show that. And I have a couple more pictures here that will demonstrate that there was a side door there. And then I'll tell you in a moment why I chose the side door instead of the front door. I was counting on a big table here to spread things out. This is tiny to work off of. This is tinier than my lot. I'm sorry?
Do you need these back, but these are all copies?
I practically need nothing back.
Okay.
You may have this one.
Okay.
This is the one the inspector took 3 years ago. The busted up side front doors right there, the steps and all. It's now a window instead of a door. And the 2015 photo that Scott Tanner gave me showing a front door. So these are 3 years apart, both in their possession. That one I believe you now have too. It's got the truck parked there. And that was before I owned it. But the point is, when I bought it, my wife and I, it was in absolute deplorable condition. Completely deplorable. Backyard was full of lawnmowers, refrigerators, stoves, washers, dryers, all kinds of junk. And they're there in the 2015 photo that the county had. That 2015 photo, you can see the junk in the background. Why does nobody force it to get cleaned up? I come along 2018, I clean it all up, I do all the windows and the siding and the door. I'm thinking I did a beautiful thing. Andy thought I did a beautiful thing. The county inspector didn't think I did a beautiful thing. He gave me a violation. At any rate, here it is. To help show there was a side door, that I did not create it, and then to explain to you why I got rid of the front door, a front door that the county knew about when I did the last permit 3 years ago. Here's a picture of the inside of my house when I bought it 3 years ago. Next to that picture is the house today. And you will notice the 3 windows, and in this picture you'll see the 3 windows and a large cabinet blocking the 3rd window. But this just helps confirm for you you're looking at the same area. You'll notice the side door that I allegedly created this big violation with. Side door that was there when they did the last permit, side door was there when they did the last and final inspection. You'll then notice in the same room, the day I bought it, and I took this picture, just like I took those outside pictures that are horrible, there's a hallway here. That is the side door that you can see from inside the house. I don't have any pictures, neither does the county, of that side of the house 3 years ago, or even 10 or 15 or 20 years ago. Nobody has them. But on that side, it had all been done in with white aluminum siding. It appears to me that was all done when the 2 additions were put on, because everything's all part of one. The side porch that had gotten enclosed, they closed up the door and went right over it with the white siding. So there was no door there that you could see from outside, but there was one on the inside, and they had begun using that hallway as like a closet, clothing and other junk. And I mean a lot of junk. The front door was still there, but it had all been screwed shut, and on the inside, they had covered it with paneling, ugly 1970s brown-looking paneling. There's a couple of reasons they did that, my wife and I concluded after we got the house. The front door walked right into the main bedroom. This is a tiny house. It's 1,000 square feet. You would open the door and you walk in, there's the main bedroom. Also, the front door had the steps and the handrail and the concrete steps that you see in the one picture, the 2015 picture from Mr. Tanner. That protruded a total of 7-8 feet out. And as I've demonstrated to you with other pictures and my fantastic drawing I did over here, there's no room to park. When we got it, the door was sealed shut on the outside, screwed shut, sealed on the inside, and that way I guess their bedroom no longer had a front door coming through it. Also, the front steps, which are concrete, it was one of those hollow cast concrete, not all solid. It was a hollow precast, you bring it in, set it in place. That, on the day we bought it, had been slammed into, I guess by the previous owner's truck, so many times, it was all busted up. And it's the remnants of that step that's in my picture that was there the day the inspector came. So I'm trying to demonstrate to you, we have non-conforming lots. My lot's the smallest. Parking is extremely limited. I've shown my parking situation. When I got there, the front door was sealed off. The side door had been gone over with aluminum siding on the side, and the porch had become part of the house. Permits here from 75 and 77, Mr. Tanner, reflect that. And they were using only the rear door, what you would call the rear door. We at the bay, we call that the front door because it faces the bay. They were using only that door to come in and out. And as we began fixing up this house, my wife and I said, we have to have a second door. You can't, with fire and so on. So of the 2 doors that we discovered, one was on the side, one was on the front. We went with the side door, knowing I needed a space out front, seeing all the damage to the concrete steps, knowing how much they stick into the driveway. I went to my brand new neighbor, Andy, and asked him if that would trouble him any. He said no. I began all this work, and I probably spent a month on it, roughly. And that's when the county showed up. And they flagged me for everything, and I took care of it. I did the appraisal, I passed the 50/50, I pulled permits. I thought everything was behind me. And now 3 years later, this has come back up. I'll explain to you in a moment why it came back up. I would like to show you, when you look at the 4 areas that I have to pass, the first being the setback itself. I can't meet the setback. There's not 10 feet there. I have 6 feet. I can't possibly meet the 10 feet. That's what a variance is all about, is to try to work with homeowners who have a unique and difficult situation. That house was built in 1930. It's a very tiny lot. I'm very limited. So I need to have a variance for the setback because of the situation. The second thing is it in keeping with the community in the area? I have photos here. I walked around just the other day, and in 10 minutes, I took pictures, approximately 20 pictures here, throughout our neighborhood of home after home after home, where either the structure, the side doors, the fence lines, the sheds, whatever we might be talking about, because there's all kinds of pictures here, all very tight together. That's how it is at Kitshummock. There's a variance for everything down there because the lots are so tiny. I'd like to give these to you and ask you just to look at them, and you'll see examples that my request is very much in keeping with the entire community. I'm not talking a few houses. Our neighborhood is just laid out this way, and your own planning map demonstrates that when you look at the slimness, the tininess of all those lots. But if you review these photos, you'll see it's in keeping with the community. I have 2 more things I have to get past: the variance, keeping with the community, the neighbor. My neighbor's here for me tonight. He'll talk in a moment. And lastly, the hardship. So if you don't mind, I'll talk about the hardship. First of all, if I had to put the front door back, several things will happen. I will have a significant impact on the parking situation, and it's literally the only 2 spots I could put my car. There is no street parking. There is none. You do not park on the streets of Kitshummock. Everyone must park up in their community. There's no curbs. There's no sidewalks. This is a beach-type community. I don't know if some of you have been through there. I do not own another lot across the street or something that's part of this parcel. That's it. Those 2 spots are all I have. And when we park our vehicles there and open our doors and open the rear hatch to get groceries and everything, we have just enough room behind us to barely not bump the front of my house. I have just enough room to get the nose of the cars in so that the postal lady and the trash trucks and all the other vehicles aren't hitting the front of our cars. It's very tight. I would have a extremely difficult time with parking. It would be unsafe as far as getting out of your vehicle and trying to get over or past the steps that are now protruding out. It's a major tripping hazard. There would be damage to the vehicles. It would be inevitable. We will back into the concrete steps just like the previous owner did. If I'm not careful right now, even with the steps removed, we get pretty close sometimes to hitting the house. I mean, it's just that tight. You can look at the pictures and see. We would also have a fire hazard, a safety hazard. If I have to remove that front door or that side door, I'm not putting a front door in. There's no way. I'm not going to have the door come in my main bedroom like it used to. I'm not going to have steps protruding out into my driveway, hit them with my vehicle, have my wife or I trip on them and break our bones. We're both almost 60. I don't need that. So I will have 1 door like the previous people did, and that's just not safe. It would be very costly for me to do this. And there was another hardship. I have to refer to my notes. I apologize. I can't remember everything anymore. Yeah, fire egress, more than 1 door, the parking, and the bedroom situation. I mean, literally the front door. It's weird. You guys have been in some really old houses where you go through 1 bedroom to get to another bedroom, where you come into a door and you're in the bedroom, which was my case. You came in the door and you were in the master bedroom. So I hope I've demonstrated that we need the setback. The setback is not there for me on either side, nor is it on the front. I'm supposed to have 15-foot easement for Del Dot, 25-foot setback for the house. That's not completely impossible. These lots set up 50 years ago don't meet today's requirements. I hope you'll see from the photos it's very much in keeping with the rest of the community. I hope you'll see from the maps that were provided from your planning department that all the lots are very tiny and mine is the tiniest. I hope you'll agree those are sound, good reasons for the whole door situation, fire, parking, egress. And I hope I've shown you evidence that there was a side door on that house at one time. The porch from the 1975 survey that Andy gave me, that just came to my awareness a few days ago, thank goodness. And the photos I showed you of the inside of the house that show that area, you can see in the old photo, there's a hallway there. That hallway was the side door. The one other thing I need to convince you folks of is that my neighbor's okay with it. My neighbor Andy is here. I'm going to have him come up and speak. I do want to say one more thing as far as in keeping with the community goes.
Mr. Burrows,
This is vital, and I'm done.
We're getting long, okay, because
Okay.
I
house,
want to be fair. But
this is vital. The house on each side of me, which would be Andy's, and Andy knows this, we're okay with this, and another house on the other side of me. Andy's main structure, his house, has an addition on the back, put on a long time ago, way before I bought the house. His addition, which is his house, is 4 feet from the property line. The house on the other side of me, right next to me, that house, the entire house, the whole structure, is 2 feet from the property line. I'm asking for a wooden boardwalk, not a structure, not a big house, a wooden boardwalk and a little landing to get in. And it's been there for 3 years. I thought it all got addressed before. It's come up again now due to a ugly situation that was avoidable. I hope the information I provided you will be helpful in your decision. I would appreciate your support, and I would ask my good neighbor, Andy Mariani, to speak next.
Okay.
Thank you.
This group
Wait a
may have
minute.
some questions.
we
for
get
you.
to ask you questions.
Okay.
So, just for information, this board hears from time to time applications on Kits Hummock. So some of what you described, we realize. And the staff recommendation for this evening's hearing for your application is that we deny. Now, of course, that's not based, we also base our decision on testimony, and
Yes.
so, okay. I have one question, which is, and I'm going to show this to the planners because they have the photos. This photo, can you put that up, bring that up for me?
You wanted to project it out?
I want to see, yeah. Okay, sorry then. It's okay. But I'm going to show it to you.
Okay.
I want you to tell me what's on the side.
What's on the side?
Yeah, he's going to bring you this photo, and I
Okay.
want to know.
What's that? Oh, that is the neighbor's house on the other side that's 2 feet from the property line. That's not mine. If you look at the black asphalt on this driveway, that asphalt is my limit.
Okay.
I cannot go any further over. And that asphalt goes
Okay.
side of my house. I have 3 feet on the side of the house, 3 feet.
Okay.
That asphalt, that's it.
So will you pass that just so that everybody on the board can see what I was asking, what I was talking about?
I thought I passed up the last two things I said were real vital, and I handed them. That was Andy's house, how it's 4 feet from the side. And the other picture is the very house you're talking about. It should show the orange spray paint of the survey marker at the front of the driveway.
Okay.
And if you look at that marker and you look in the picture straight back, you can see the house next to me way over. It's 2 feet off the property line. My only point is there's lots of houses down there. I'm talking houses, not boardwalks.
Okay,
Houses
so this
that are
is
5 feet, 4 feet, 2 feet from the line.
okay. So this is where we're going to ask you questions. Okay,
Yes.
so anybody have any questions of Mr. Burr, Mr. Townsend?
So is the land-in permitted now? Right.
I'm sorry?
Is the land-in right here?
I can't tell who's talking with the mask.
So is the deck/landing, is
That landing is permanent. That was put in 3 years ago, so it can come in the side door, as is that boardwalk. And the one photograph I provided of the inside of the house with the 3 windows and all, that's that door.
Yep. Thank you.
So that's the landing and boardwalk. That's Andy's house right there to the left, and that addition off the back that goes over and out, that's 4 feet from the property line.
If I may, the deck in question is there where the steps are. Yes,
That's
that is
correct.
what's in dispute.
That
If
is-
that were 4 by 4 feet, we would not be here today and tonight. The question is, it's larger and it's closer to the property line. A 4 by 4, whatever distance that would extend toward the property line would be fine, but it's larger than that. That's the variance.
Let me comment on that. A 4 by 4 is extremely tiny when you have your mother, your father, the Walkers, all 4 of my parents in their 90s. When I have my wife with me in the groceries, it's just, I didn't realize 4 by 4 was the rule. This is like 5.
Right, but
the
it is
7
the rule.
The 7 is coming this way, not towards the property line. It's 5 by 7. It's already built. If I took off a foot, it wouldn't make a hill of beans of difference. Andy and I are still right next to each other, and we get along fantastic, and he's the only house affected by this. If I move that 1 foot, it makes no difference.
So this was permitted, so how did it not get?
So the question, is it's been built and at this time it exceeds the distance at the size. So without a variance, it can't stand.
So, but this was permitted 3 years ago, correct?
Jamie's telling me it does not have a permit.
No, if you
We didn't permit decks because there's no roof. Is that so? I mean, he wouldn't have needed a permit to build?
Yes, ma'am. It does require a
It did.
permit because it's over the 4 by 4. There is not a permit for that deck.
Yes, and I'm very willing to pull the permit and correct this situation, just like I did last time, and I thought I had done all that time, because the inspectors came out. They walked all of this with me. Siding, windows, doors, they walked around, they went right up that landing. We looked at everything together after it was done. He was also there prior to that to give me the violation and make me go through the appraisal and substantial improvement and all. It's been there for 3 years. It's never been an issue till now due to an ugly situation that occurred in the other direction. I am willing, very much willing, to pull the permits and for the landing. That's not a problem. I just need the variance to say it's okay to be on that side of the house. I can't get 10 feet no matter what I do. I have 6 feet.
Okay.
So if this is 4 foot or 5 foot, it really doesn't, it's going to cause me to have to spend all kinds of money to take off a foot.
Anybody else? Questions? Thank you.
Okay, thank you very much.
Okay, thank you, Mr. Burrows. Is there anyone else who would like to speak in favor of application? And please, we've run well over a half an hour on this. Please be focused in your support for it. Thank you. And please state your name and address and allow our attorney to swear you in.
My name's Andrew Mariani. I've been living on the beach longer than anybody. My house is right next to Dan's.
Mr. Mariani, what's your Mr. Mariani? Right here.
Oh.
What's your address, sir?
112 North Bay Drive, Kitshomick Beach, Dover, Delaware.
Very good. Do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Absolutely the truth.
All right. Please proceed.
I live right next door to Dan. My house is property line with his, where the easements he needs. He asked me before he did this if I was okay with it. I said yes. I'm still okay with it. We can't do a whole lot of things the way you're supposed to do them down there. And it's been like this for 50 years. Like he said, my front porch is 4 foot off the line. It's been like that for 50 years. And many homes down there are the same way. We can't conform to these 10-foot sidelines. I think we have about 12 foot between us. So everything he says is true. And I'm not going to repeat everything because you guys heard it. But I am in favor of this easement. And that's all I have to say.
Is it clear which side you're on? You're on the side.
My house is on the left there.
Very good. Okay. Just for the record, I wanted to make that clear. Thanks.
And that don't bother me at all. I cut grass through there. I walk through there. Our neighbors, we walk through each other's yards. We're friends. Everything's cool.
Anybody, any questions? Thank you.
Thank you, Mr. Mariani. Is there anyone else in the room who would like to speak in favor of the application? Yes, sir. Please come up, state your name, address, and allow our attorney to swear you in. Thank you.
Yes, good evening. My name is Michael Costello. I live at 3063 Kitshomick Road, Dover, Delaware.
Mr. Costello, do you solemnly swear the testimony you give in this proceeding will be the truth, the whole truth, nothing but the truth, so help you God?
I do. Thank you. I am one of Dan's neighbors. And first off, I bought a lot there 21 years ago. And it was an undeveloped lot. Wasn't anything on it. Bought it. Had a surveyor come out. He said, you got a problem. He said, are you aware there's a house on your property? I said, no, I didn't buy a house. I bought a lot. He said, no, you own this house. It wasn't even on the tax rolls. And this was in 2000 or 1999. And then he said, oh, by the way, the house next door, you own 3 foot of its living room. The property line went right down through the guy's living room. Now, hey, what can I do about it? I bought the property, tore the house down that was there, put a nice home up, and lived there ever since. It's a great community. Second thing is, I met Dan a couple of years ago. He said he was interested in this house. There was a gentleman who owned the house who was a veteran, disabled, Agent Orange from Vietnam, and drug addict. And the house was crap. Don't mean to disparage his character, but he was a hoarder. The house was full of crap in the backyard, in the front yard. And the guy died, overdosed one night. We had to have the cops go in and bust the door down to find his body. In his will, he left it to his buddy, who was also a drug addict. He was in jail. So the buddy says to his friend, you can come live in my house while I'm in jail for 5 years. The guy who went and lived in the house turns out to be a sex trafficker. He's a pimp. All day and night, people come, go into that house, and we finally met the woman who was there.
I'm going to stop you here. So, we need to talk about the variance that we're talking about.
Okay.
So, yeah. Any past, it's not relevant to this.
Okay, I agree. My point is, this is a good guy. And I'm sorry he's in a little bit of a jam with the setbacks. But everything in Kitshomick has issues and stories. He's a good neighbor, and we wouldn't be here supporting him if he wasn't. So thank you.
Anybody any questions? Thank you.
Thank you, Mr. Costello. Anyone else who'd like to speak in favor? And again, please focus your comments on the variance. Yes, sir. Please come up, state your name and address.
My name is Tim Goodwin, 122 North Bay Drive.
Sir, do you affirm the testimony you give in this, or do you solemnly swear the testimony given in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. So I live 2 doors north of Dan. He has done an awesome job of cleaning up the neighborhood, and we appreciate that. My wife and I do. If you look at this picture right here, if he were to put a door, because he needs to have 2 access, if he were to put a door where that middle window is, as he said, and I'll attest to the fact that that porch would then go into his driveway. In order for him to park cars in there, they would come out to the road, be a blockage of the road. This is a beach community. We don't have any sidewalks. People, my wife and I, and a number of people walk up and down that road all the time. It would be a safety hazard if those cars extended into the roadway, not just for the trash trucks and the mail people and those people that support our community, but as well as the people who walk up and down the road. It would be a hazard for them to walk into the road in order to get around the cars. He would have to extend in the road if he were to put a porch on that end of the house, on that side of the house.
Anybody, any questions? Thank you.
Thank you.
Thank you for your testimony. Is anyone else here that would like to speak in favor? Yes, sir. Name and address, please.
Richard Rogers, 42 North Bay Drive, Dover, Delaware, 19901. I just want to...
Mr. Rogers?
Yes?
Do you affirm the testimony given in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes. I just want to agree with the variance, that he would get the variance because he has really helped clean up this community. Thank you.
Thank you.
Thank you, Mr. Rogers. Anyone else in the room who'd like to speak in favor of the application? In favor? Okay, seeing none. Online, Mark, is there anyone online? If you're online, please push *3 to raise your hand or *6 to unmute.
No one online wishing to speak in favor at this time.
Thank you, Mark. Okay, that's all the testimony in favor. Anybody in opposition to this application? Opposition in the room, please come up. Thank you. State your name and address. Again, we're running long. If you could kind of focus your comments on why the variance would impact you.
My name is Aaron Alberti. I'm at 94 North Bay, directly adjacent to his property.
Mr. Alberti, if you would raise that microphone to your face. Very good. Now, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
All right, please proceed.
All right, I put under contract to purchase 94 North Bay Drive in Dover, Delaware. I'm the house directly I'm the other neighbor directly adjacent to Mr. Burrows. Can you all hear me? All right. I purchased this property under contract on August 24th, and we settled on September 24th. On September 11th, I received text messages after leaving my number with Mr. Burrows when I was looking at the property earlier. He sent me a text message that reads, and I'm going to give you this entire packet, and I won't bore you with the 30 pages of documents. I can just leave them with you. But I do contest Mr. Burrows getting a variance to build right there, regardless of how friendly his other neighbors are. This is to inform you that the entire rear addition is built on the V line. I know Kits Hummock I purchased the property because I was going to bring my family there. We were going to go fishing. I'm not as old as these guys. I haven't been there that long. I was going to do some repairs. I was going to upgrade the kitchen. I was going to do some things, but I haven't done a thing. And I got a text message from Mr. Burrows informing me that the entire rear addition that I had on this house, that by the way was built over 35 years ago at least, was built on the V line, kind of similar to some of the other houses they spoke of. This is a DNREC flood line. The rear and front additions were constructed without permits, as you know.
Mr. Alberti?
Yes.
You're referring to matters that involve your property on the right side?
Yes. I'm directly to the right.
Okay, so we're here to hear whether Mr. Burrows has an exceptional practical difficulty in locating second access to his home.
Right.
So could you speak to that issue?
Yeah, I believe that this I believe that as a member of the community, that I believe that we ought to all be playing by the same rules. We were aware of what we buy. When we bought it, he bought it 3 years ago. You can't just, we wouldn't be here if Mr. Burrows got a permit. I think the time to ask for a variance is before you build, not after you build. You get caught, and then you ask for a variance. I don't think that's how it works. If that were the case, then everybody would build. In fact, I have, Mr. Burrows has told me that I'm not allowed on his property to even renovate because I only have 3 feet, which is actually not true. And I believe
so now we're getting into acrimony, like,
Sure.
you know, like, so.
I guess in summary, I contest it. I think I have the right to contest it as a neighbor.
You absolutely have a right to
And-
speak, but
and
I just don't want this, I don't want you to just, this board does not deal with what one of the older women used to always say, bad blood. We don't deal with that. So
I don't have any bad
Okay.
blood. I just
Okay.
felt like that we listened for almost a half hour about how
and
good,
I'm willing to listen to you.
right, for
Okay.
about how good a guy Mr. Burrows is, and that was one of the reasons that he should be able to not follow the same rules that we all have to follow. And I think that as part of this text message, that is relevant based on his testimony, that if you own other property here or near Kitts, I will be coordinating our community board, which I suppose are these guys, even though I've never heard them be referred to as that. And as an organization, we will be addressing each property, plan to demo homes and address other property issues that we identify. So Mr. Burrows and his wonderful neighbors here have some sort of coalition to demo people who purchase properties in this neighborhood. This was a threat that was made to me, and he apparently wants to build decks without permits. He wants to, I guess, not get the proper footers. And as everyone knows, in Kitts Hummock, there is not just Kent County rules, but also FEMA rules. And they are more stringent given that we're in a floodplain. And if he is allowed to just build whatever he wants, whenever he wants, until he gets caught, insurance rates will go up. Of course, and we talked about precedent. I sat here and listened to almost an hour and 20 minutes about precedent. Then everyone should be allowed to do it. And I think that Kitts Hummock, these guys seem like nice guys. People have told me I'm a nice guy, but I think we have to play by the rules. And if Mr. Burrows, I don't believe that, at least in any property I've ever lived in, have you been allowed to simply build decks outside of your property on neighbors' property just because you're a nice guy. There's rules we follow, and I think you ought to be held to the same rules that we all are. And I'm sorry for leaving. These threats are pretty alarming. I think some of them are extortionary, and I think some of them are borderline racketeering. And I think that we're going to look into that as well for criminal purposes.
Those issues are a civil matter.
Right, I get that. But of course, I thought we were limited to 5 minutes. We listened to a half hour of how nice everybody
and I'm
is.
happy. I'm listening to you as
Right.
well.
Okay.
Absolutely.
And so that's all I have to say. I do contest it. I am the next door neighbor. I believe there are other structures on that property as well that aren't even haven't even been brought up. In the back, they're built on past the DN rec line. That's a no build zone, and I think he's ignored that. And I think that Mr. Burrows is no stranger to this room. I think he knows exactly what he's doing. I believe he's a licensed contractor in Wilmington or something. So he's not as ignorant as he appears. And I think that he needs to get a proper permit to build whatever he wants. And then if the board would like to issue a variance, I think that's the way things are done. Not to do them, then ask for variances because you got caught. And then come in and bring people in an intimidating fashion and say that we're all a bunch of nice guys here. I don't think this is the good old boy network. I don't think Delaware operates that way. So that's all I have to say. I appreciate it.
Does anybody have any questions?
Yes, I do.
Sir?
Oh, I'm sorry.
In your opinion, How are you impacted by the fact that your property is 2 feet from Mr. Burrows? What's your impact?
I think my impact is that I cannot, he has warned me that I cannot renovate the side of my property, meaning paint, put siding, because it's too close to his property, and he would not allow me to come on his property because I guess I wouldn't be able to fit either a scaffold or a worker within 2 feet of his property line. This has come unsolicited from him, and I just feel like if the reason for building illegal decks is that we're all just a bunch of nice guys here, I don't see that as a reason. I haven't experienced that niceness.
Anybody else? Thank you.
I do have to, one more thing.
Sure.
This property, we have gotten broker price opinions of well over $200,000. And because of Mr. Burrows' actions, it's now, we believe, will not be able to be sold for much more than the mid-100s. In fact, he's made offers too, which is where the extortion comes from, which has lowered the property value by a significant amount, I believe over $70,000. And I think if he continues to behave the way he's behaving, he's going to lower the property values in the entire neighborhood. His friends don't live next door. I guess one of them does, but I believe that there's other people in the neighborhood other than these 4 people. In fact, I'm a member of the neighborhood. And I didn't know of any community association, no community board, to where people could organize to have you. I haven't even touched that house. I haven't done anything. I've been in contact with Scott Tanner. I've been in contact with Sarah Kiever. And they have told me that, the good old boy network, where everybody just lets you build on each other's property, it only works if everybody's kind of getting along. We learned that in grade school. So when you start to make enemies with people, that the rules are always the basis for decisions. It's like my ex-wife's judge said, look, you can agree to anything you want, but if you don't, you got to follow the court order. And Mr. Burrows has been an absolute nightmare to be next door. And I can tell you that he was a nightmare to the previous owner, who did not have the financial capability to stand up to him, or the time. You have to sit here for over an hour and listen to this over and over and over again. And I think that I have the financial ability to stand up to a tyrant like this, and I will.
Any questions, anybody? Thank you.
Thank you.
Ms. Diddy?
I'm sorry.
We're just taking the hearing, all the comments for being in favor of the application of closed. We're now doing in opposition. We fairly listened to everyone who is supportive. So now we're moving on. Is there anyone else in opposition to this application? Thank you, sir. State your name and address.
Hello, my name's Joe Alvampato. My address is 1013 Morrison Boulevard in Havre de Grace, Maryland. I'm not a resident of Kitts-Hummock, but I do represent the owner of said property, and I am here to, further reiterate.
Sir, do you solemnly swear the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir. So like I was saying, I just wanted to further reiterate, and I'll be brief. We've been here long enough. Just the experience that we've had with Mr. Burrows. And it is obvious, like Mr. Alberti stated, that he is very familiar with the process, very aware of what he's doing and what he's not doing. And honestly, I think that in my experience, my interactions with him that I have documented, but that obviously that those conversations are not meant for this forum, that he seeks to use his knowledge of this process, not to necessarily better the community, but to, to further his interest, to serve his interest. I don't think he has the interest of anybody else. It's nice that there are gentlemen here to support him, and I'm sure that those relationships are positive. But, just to speak to what Mr. Alberti was, referring to earlier, I do have the house listed, marketed to sell, and he is, whether he is aware or not, driving the property value down by harassing potential buyers, basically using his knowledge and sort of cherry picking pieces of the process and pieces of code to give inaccurate information to potential buyers and potential agents. And, no matter where you are, I just don't think that I don't think that that's good. That's not good business, and I don't think that it's ultimately good for the community of Kitts-Hummock. Even as someone who is not a part of that community, ultimately that is not good for the community. People who behave this way and use processes and systems like this to only further their self-interest, I don't think are ultimately good for the community. And like Mr. Alberti said, I truly believe that there should be a level playing field and that there shouldn't be favoritism or any sort of difference in the rules that people have to follow in regards to, these types of processes and codes. Like, let's not forget that these types of codes are put in place to keep people safe and to, keep property values up and to keep communities, functioning in a positive way. The fact that we have to have this type of conversation about this process and the way Mr. Burrows has handled himself throughout this process, is a little upsetting. And we drove all the way from Maryland to make sure that we made that heard. And I hope that you guys understand that. And I appreciate your time.
Okay, and I'm just going to say one thing, and it really, for both of you, is that the code is specific, but it's also specific that we have a board who hears variances when you have some exceptional practical difficulty. So I just want to assure you that that we're part of the code, and it is up to us as a body to review these as we are and to hear testimony from both sides to see if there is an exceptional practical difficulty, which would make a reason why this should happen. Okay, so just to assure you of that. Yeah, and
I appreciate that. Thank you.
Thank you for your
and I
testimony.
appreciate you guys hearing us this evening.
Thank you.
Thank you.
Okay, thank you. Is there anyone else in the room who would like to give testimony in opposition to this application? Opposition? No? Mark, is there anyone online? If you're online and you would like to give testimony, again, in opposition to this application, please push *3 or *6 so we can identify you.
Just for the record, you're raising your hand. We do not hear rebuttals. You had your turn. Actually, I let you go long. You had your turn to speak. No, excuse me.
We're not going to hear any back and forth at this point. So.
Okay.
I see no hands raised in opposition online at this time.
Thank you, Mark. Okay, having heard both testimony in favor and in opposition to A2143, the hearing is now closed.
Okay, so we're going to have a 10-minute recess because we have some people who have asked for it.
Dan? Yes. Who were those guys? We've never met them. Is that the guys that were in the car? Well, how are they our neighbors? No, carried over from Steve. They carried over from Steve. Oh, I understand that, but he's not a neighbor. I mean, I've never met the guy. Well, and we're not a good old boy now. I'm sorry, we were slandered.
got mine. I'm gonna wait for the business portion.
Oh, okay.
Yeah. Second portion take as long as first. I've never been through this before, so I'm just kind of learning, see how it goes. But I can stay in here then? Okay. Yeah. I've never been through this before, so I'm just kind of, thanks.
Okay, so we're all back. Will you call the roll, please?
Ms. Hudson.
Here.
Mr. Saunders online.
Here.
Good to hear your voice. Great. Thank you. Mr. Jenkins.
Here.
Mr. Kuzic.
Here.
Mr. Nichols. Just roll call, sir. Yes, he's here. And Ms. Stenny.
Here.
Vote shows 6 present. We have a quorum.
Okay, so we have a quorum. At this point, we will hear the cases. We're going to call the business meeting to order. And the first order of business is minutes from last month's meeting, and I will I'll abstain because I was not here for last month's meeting.
Yeah, so we'd need a motion to approve the minutes from last month.
We're looking for a motion for last month's minutes.
I'll make a motion to approve the business meeting minutes of the October 21st, 2021 meeting.
I'll second that.
Okay, so we have a motion and a second to approve the minutes from the October 21st, 21 meeting. All in favor, say aye.
Aye.
Any nays?
Aye.
Thank you, Mr. Saunders.
And then I'm abstaining.
Aye.
Okay, got it. Okay, next order of business is the notice of decisions, and those decisions are, I think, I wrote them down somewhere, 20, 37, 38, and 39. Sorry, and 29.
I'll make a motion for the approval of the notices of decisions for A21-29, A21-37, A21-38, and A21-39, which were from the October 21st, 2021 meeting.
I second.
We have a motion and second to approve the notice of decisions from the October 21st, 21 meeting. All in favor?
Aye.
Aye.
Any nays?
Aye.
Hearing no nays, and I'm abstaining as I was not here. Appears as though we have no old business. So with new business, we're going to do deliberation on tonight's applications, and we'll hear them in the order of those who remained first.
Thank you. So the Browns are still here, so we'll go with A21-42 first.
I have, my papers are all over here. Hold on. Okay, so at this point, we're looking at A21-42, which is Kent and Farron Brown. Any thoughts or discussion?
I just wanted to comment that, you know, when you look at the overall nature of what's going on here on this parcel, I mean, we all know it's an extremely excessive request, but they have made some effort to try to come to terms with some drainage and other issues. So,
anything else? Okay, so I certainly agree with you, Mr. Jenkins, just as a matter of discussion. So at this point, unless somebody else has comments, then I'm going to look for a motion.
I'll make a motion to approve application A21-42. Per the testimony, the hardship that they stated to tear up the asphalt, the financial hardship is there. As long as they did their due diligence with the KCD approval, and they also went the extra step to get an environmental scientist out there to research the soil in that area, so on their property. So I'm going to vote yes.
I'll second that.
Okay, we have a motion and a second. When you're ready, call the roll.
Thank you. Mr. Saunders?
Yes, I vote to approve A-21-42 based on the letters that are in favor of it, based on their testimony, their due diligence of what they did, and I don't think the restriction would cause any serious effects to the neighboring properties based upon the drainage and all that.
Thank you. Mr. Jenkins?
I vote yes in support of application A-2042 based upon the testimony not only of the applicant, but the other testimony, I believe, from the staff and the evidence that we have about the nature of this parcel.
Thank you. Mr. Nichols?
Sorry, on A-21-42, I vote to approve the request for variance. It appears that it wouldn't create a drainage problem. The neighbors are in favor of it. It seems to be in character of the zone in which the property lies.
Thank you. Ms. Hudson?
For A-21-42, I vote to approve. The applicant has an exceptional practical difficulty, and I see where the character, use, and zone of the property does not change, and the exceptional practical difficulty to have a contractor come in and rip up the asphalt would be an economical hardship. And I believe the applicants are willing to work with the board by saying that they would move their daughter's playhouse on top of the service to give more groundwater clearance. But they also went above and beyond with their environmental scientists that came out and said that there was no water. So I vote to approve it.
Thank you, Ms. Hudson. Mr. Cusick?
I vote yes for my motion.
And finally, Ms. Stenny?
I vote no. I think it's an extensive amount of macadam. And I think, we're plagued sometimes with these impervious soil issues, and I think 40.6% of impervious soil is not a good thing.
Okay, thank you. So the vote shows 5 yeas in favor to approve and 1 nay.
Having received the appropriate amount of positive votes, application A-2142 is hereby approved.
Okay, thank you. So the next one, we'll take them in order, is A-2140. That was Samuel Miller looking for a variance for road frontage to do a minor subdivision.
I'll make a motion to approve application A-21-40 based upon the testimony of the applicant and the fact that the road frontage is so minute, I don't think it will damage the character of this particular parcel and the area surrounding it at all.
I second.
Okay, we have a motion and a second. When you're ready, call the roll.
Okay, let's see, Mr. Cusick.
I vote yes to approve application A-21-43. The unique lot, the smallest in that area, and then as the testimony stated, as the applicant stated in the testimony, that all those lots within that area are bordering the property line. So the hardship is there, as stated in his testimony, with the lack of a driveway. If they had a front door on the front of the house, and then also the fire.
I think we're on the Samuel Miller, the one with the road frontage on Diners Corner Road. This isn't the Kitshummock.
Are we doing that one?
Get back from the beginning.
Yeah, he's not the applicant.
He's not the applicant.
He's just
the listener.
All's good.
We tried to confuse you.
Yeah, I vote yes to approve application 821-40 per the staff recommendation. The hardship to be able to create that parcel for his deed, and it's just no impact to the neighbor properties, and it won't be noticeable.
Great, thank you. Mr. Nichols?
Yes, I vote to grant the approval as noted by staff.
Mr. Saunders?
Yes, I vote to approve A-21-40 based on the staff recommendations and also from testimony. And I do not believe that it will. You wouldn't see the effect. You wouldn't notice the effect of the change.
Thank you. Ms. Hudson?
For A-21-40, I vote to approve based off staff recommendation public testimony that we heard tonight. I believe the nature of the zone where the property lies, the character and the use of the property does not change.
Thank you. Mr. Jenkins?
I vote yes per my motion.
And Ms. Steny?
I'm going to vote yes. Certainly, I see that there's an exceptional practical difficulty just by the way lots were laid out back then, and we are looking at such a small amount of difference. Thereby, yes.
Thank you. So the vote to approve has 6 yeas and 0 nays.
Having received unanimous positive votes, application A-21-40 is hereby approved.
Thank you. The next one is A-21-41. This is the Corbetts. This was for the variance for the size of the pole building, or the accessory dwelling unit. I apologize.
Okay, so thoughts, discussion, or a motion?
I think this one was a hard one because I couldn't quite understand if he was going to be an attic for storage or if he was going to use it.
His testimony, to the best of my recollection, was that the attic at the moment was just really because of ventilation space, and he didn't have plans to put anything up there. Downstairs, and I used the term office, and he said, no, not an office, but a place where they would have live video of his services for the public. And I did ask, I said, nobody will be there. And he said, some people will be there. And I asked I said, how many? And he said, about 8. So he certainly didn't appear as though, based on testimony, he planned on using this as a church that people come to, which would eliminate like traffic and other issues that might come about. And certainly if he did make it a church, if that changed, then there would have to be hearings beyond for that.
I know for me, storage was a concern, and he said they were storing things in a building not too far from where they want to build. But I'd be concerned because I even asked him, if the attic space was not approved, what would he do? And I never really got a clear answer that either they would, if they're paying for rent now to store it, or what they would do. But he was just trusting that we would go along with it. It's kind of what I got. Maybe that was not.
Yeah, I think, I agree. I think he didn't know what he would do if that changed and the building wasn't approved. I think he's kind of at a loss.
Did he give us a reason why he couldn't building by, what would you say, what is it, 2 feet or something?
Well, it was was that? I don't know. I thought there was, the question was asked about, did you ask it? Somebody asked about, no? No, I think I guess the attic space was addressed, Yeah,
I said, why couldn't you drop because he said he didn't need a variance if the ceilings were below 7 foot.
Correct, yes, if it were 6 feet.
Yeah, and I think he said he was 6 feet tall or 6 something, yeah. So.
If I could, Ms. Denny, I want to commend the board for this type of deliberation prior to making a motion. I think oftentimes if you wait to express thoughts like this during the course of voting for or against a motion, it's kind of too late for the rest of the group to benefit from your questions and your thoughts. So again, I want to encourage the board to continue to do this as you're doing tonight.
And essentially, most of the building, I guess, is to be used for storage of the crops. I mean, they're going to farm, and they're going to also have, I mean, they're doing an agribusiness, and as well as then part of it is going to be solar panels that, you know, for the electricity. So to me, I think it's reasonable. And again, the one testimony against it was concern for traffic because of a church. That's what, and we know that that is not the case.
That's correct. That would be, I believe, a conditional use in this zoning district, which would be considerable. There would be a public hearing both with regional planning and levy court if he applied. So, and to the neighbor's one point, just to share with you, if he did build it as the size of the house, which is 2432, again, he wouldn't be here tonight. We would have issued the permit. He is allowed to build a structure of that size, just not larger. So it's worth considering how much larger, as we have in the past, that he's asking to go above the 2432. And in some cases, maybe a modified approval, you know.
Well, even when I asked him about the 2280, he didn't have a definitive answer to me. He based that on the fact that that should be approved by Kent County because it's under the size of his primary residence. It's not like he had information to say, I need 2280 because of these reasons. I asked him, I said, where did you get that 2280? Well, I knew that was below my primary residence. I mean.
And I think, and I have seen this in other meetings, and I probably shouldn't make an assumption, but I think he felt like the footprint size, and he wasn't, and we've seen this before, where they think of the footprint size rather than what goes up.
I think myself, I think that he didn't make a good enough case to state why he needed a building that big.
I felt like he needed it for storage, and for part of it for storage, part of it.
I agree. I mean, look at the size of this property here. I mean, they're going to be farming, solar farms. So, I mean, he's going to need storage.
He's going to need storage. And then he also is going to utilize part of it as a studio for his services. And again, I questioned, to be clear, that there were not going to be services.
I mean, I know when he was commenting on a virtual church, the advantage to that is you need really no storage because the church is virtual. You're on your computer and you're interacting with the congregation through that method. That's one of the beauties of COVID-19, really. I mean, it allowed a lot of churches to do things differently. Storage was one of them.
Yes. Well, and again, his wife is into agriculture, and there's going to be storage of supplies and crops. And that's a good purpose for a pole building.
You have a question of staff. I visited this site. There's a small, I'll call it a bungalow, to the south.
Yeah, so I was going to say, bring up
the south of the property. It's owned by an LLC, according to the records I looked at, and it's a very small home. Does staff know if anybody occupies that home? Has anybody talked to the owner?
I think he's talking about where it's cut out there.
If you go to the white building along the highway, not his principal residence, right? Not the gray structured, back to, not that.
Yeah, that one.
Yeah, I mean, that wasn't part of this. Yeah, they would have, like Jamie said, been notified within 200 feet, and we haven't heard from them. But as far as the relationship to this property owner, we're not aware of any, or whether he owns that under the LLC or something like that.
Well, I just look at that in relationship to the size of the building, that the the proposed variance is asked for. It towers over it. It's right next to it.
So we're looking, unless he has any other comments, we're looking for a motion. And again, I don't see any objection. I mean, it's a big piece of land and there's room for both buildings.
I'll go ahead and make a motion to approve application A21-41. Per his testimony, I think it does fit within the character of that area. I think it doesn't. The accessory structure that we're dealing with is not even close to the principal structure. So I think that's sort of out of play. And then the hardship that he stated, to build an additional 700 square foot additional building that he needs for storage per his testimony. He stated that was going to be a financial hardship of an additional $20,000. So I vote yes.
Okay, so we have a motion, a second. When
I'll
you're
second
ready.
that motion.
Oh, I'm sorry. Now we have a motion, a second. When you're ready, call the roll.
Thank you. Ms. Hudson?
For A-21-41, I vote to approve based off public testimony provided tonight. I believe the character of the area is agriculture and it would not change. I also believe there's a financial hardship on the applicant for the $20,000. And I do believe his comments about having the extra ventilation for COVID-19 could be good for this time. Thank you.
Thank you, Ms. Hudson. Mr. Saunders?
Yes, I vote to deny A-21-41 based upon the staff recommendations. Plus, like I said, for myself, I don't believe that he proved why he needs a building that big to me.
Thank you. Mr. Nichols?
I vote to deny A-21-41. I don't believe it conforms to the character and uses in the immediate vicinity. And staff notes, if he reduced the size of the building to 2,432 square feet, no variance would be needed.
Okay, thank you. Mr. Jenkins?
I vote yes in support of application A21-41 based on the testimony of the applicant and just the evidence of necessity, particularly when it comes to storage. It seems like he made a reasonable case for this request.
Thank you. Mr. Cusick?
I vote yes per my motion.
And Ms. Stenny?
I'm going to vote yes. I do see exceptional practical difficulty here. It's a large piece of land. Based on the testimony, his wife is into farming some of the land, and an agricultural use in that area, I think, looks to me like it blends in. And I think he's simply asking for a small amount of that to be used as a studio for his online church. And I have no fears that would become more, because it would require conditional use applications should they expand into something bigger, and then we would see them again. So, and although it was not brought up as a hardship or in any way, we have a veteran here tonight before us who's trying to make use of his property, and he has some disability as given in testimony tonight. So therefore I say yes.
Thank you, Ms. Stenny. So on a motion to approve A21-41, we have 4 yeas and 2 nays.
Having received the appropriate amount of positive votes, application A21-41 is hereby approved.
Okay, thank you. And the last application for this evening is A21-43. Mr. Burrows.
A very interesting case indeed. Just if you consider the composition of the neighborhood, in my opinion, this request is not that unusual or exceptional.
And I agree with you, Mr. Jenkins. You know, we have heard, some of you, I guess, are newer, but we've heard many applications in Kitts-Hummock. It is, you know, the lay of the land there is, you know, extremely narrow lots. I think in testimony given tonight, you know, also they're discussing safety issues by having ingress egress in two areas, and so I agree with the need for the steps or the boardwalk.
Question for the staff. So this is not permitted. So is this something we need to enforce?
Right, so Mr. Cusick, so if he's granted the actual variance from you, he will be able to maintain this size. So again, if it, beg your pardon? Right, certainly if your question is yes, this doesn't legalize it, he will still have to apply for a permit, but he will be allowed to keep that size and that proximity to the property line, versus if you denied it, he would have to whittle it back to 4x4 and would need a variance.
And that begs the question, does he need it that big, 4x4, and even like the 7, of course, is just on his property. And so does it have to be 5x7, or would 4x7? Because I think that certainly we could modify if need be, you know, and so that there's less encroachment on the neighbors' sidelines, or setbacks, but then it's long enough, because you would wonder, you know, as he was testifying about testimony tonight about seniors getting up and down and having room, but you know, for seniors with walkers and all that, getting up and down the steps, you know, these houses are on stilts, so yeah.
But so if we're gonna discuss the size, I mean, to me, the difference is like 1.3, and that seems like we would be really pushing the button to force the 4x4 versus the 5x7 for a 1.3 foot removal. I don't know that we want to go down that road.
Yeah, I agree. Even a 4 foot, like per his testimony, it's he uses it for elderly, and 4 foot is tight when you have a 3 foot door swinging open. 5 foot is like a standard size width that you would like. So I mean, if we reduce back to 5 foot, we're just picking up 7 inches. At that point, is it really worth it?
And if they have a walker coming up, somebody has to stand there to hold the screen door, so that gives them a foot to stand there. And
good point.
We've heard extensive testimony somewhat on both sides. I think the testimonies, in addition to the applicant for it, kind of outweighed against it.
Well, you know, the one thing that we don't allow, and certainly that is noted when Mr. Townsend makes his address, is the acrimony is not part of what we base any decision or thoughts or feelings on. And it sounds like there was a great deal of acrimony, but that doesn't count. So unless there's more discussion, I'm looking for a motion in a second.
I'll make a motion to approve application A21-43 based on the testimony of the applicant, and he certainly demonstrated and proved that there is an exceptional practical difficulty with how this lot was surveyed and formulated and developed for him to purchase.
I second that.
I second.
Okay, so we have a motion, a second, and when you're ready, call the roll, please.
Thank you. Ms. Hudson.
For A-21-43, I vote to approve based off the public testimony heard tonight. And for the extremely unique property, I believe that this property is really unique and does not set a precedent, and there's an exceptional practical difficulty on the owner by the lot size. And I believe the character and the use and the zoning does not change by having the variance granted.
Thank you. Mr. Kusick.
I vote yes to approve application 821-43. It fits within the community. These setbacks are all within the property lines. Got the neighboring property that's in support of this, where the side of where this deck is being built, the neighboring property approves of it. And then obviously you have the unique lots within this Kit Hummock community. And then the hardship per his testimony, if we have the front door in the front of the North Bay Drive side of the house, it impacts the driveway. And then we need the 2 fire egress exits per his testimony.
Thank you. Mr. Nichols.
I approve A21-43 because of the nature of the zone where the property lies, character and uses of the immediate vicinity, the neighbor on the side of the deck has no objections, therefore it would not affect his property per his testimony, and removing it would create exceptional difficulties.
Thank you, Mr. Nichols. Mr. Saunders.
I vote to approve A-21-43 based upon the testimony, also on the unique property, the way that it's set up, and I think he would have an exceptional practical difficulty if he had to move it somewhere else compared to the way his lots land is, the way that the property is laid out, and he needs that second egress.
Thank you, Mr. Jenkins.
I vote yes per my motion.
And Mrs. Denny.
So I'm going to vote yes. There definitely is an exceptional practical difficulty, which is found generally in most of these narrow lots at Kits Hummock. So they're very unique, and so it doesn't set a precedence for the rest of the neighborhood. However, I think it's most appropriate here.
Thank you, Ms. Denny. So on a motion to approve A21-43, we have 6 yeas and 0 nays.
Having received unanimous positive votes, application A21-43 is hereby approved. Looking for a motion to adjourn.
I'll make a motion to adjourn this meeting.
I second.
Motion second. All in favor? Aye.
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 Okay, have a good night, everybody.
Thank you, everyone. Thanks, Mr. Saunders.
You're welcome.